This is HOA outplayed. It started as a rumor and ended as a case file. Martha shoved a payment screenshot at me and screamed that screenshots were not evidence unless hers. "You do not need to understand it. You need to comply," she snapped, waving the phone inches from my face. I stood on my driveway in Fort Collins, Colorado, holding a lanyard with my keys and a gate fob, staring at a woman in a red blazer and a reflective safety vest who had just accused me of parking violations I had already paid for 3 months ago. The Villas at Lakeview Property Owners Association had a way of resurfacing old complaints like they were new, and this time it felt deliberate. I work as a warehouse forklift lead, and I cannot miss overtime. Missing a shift means falling behind on debt payments, and I have been clawing my way out of a hole for the better part of a year. One bogus collection notice could ruin months of progress, and Martha knew it. She held a clipboard with a violation notice between us, the wind whipping loose papers around her feet. A neighbor watering the lawn paused mid-spray to stare. "This is not new," Martha said, tapping the clipboard. "This is from June. You never submitted proof of payment through the portal." I pulled up my phone and showed her the confirmation email with the timestamp. She squinted at it, then shook her head. "I do not need proof. I have paperwork and vibes." That is when I knew this was not about parking. The cold case started 3 years ago. A stack of violation notices appeared in mailboxes across the neighborhood, all dated the same week, all claiming residents had failed to submit vendor authorization forms that no one remembered receiving. The complaints vanished as fast as they came. No hearings, no follow-up, just a quiet suggestion that everyone pay a small fine to close the matter. Most people paid. I did not, because I had never hired a vendor that month. The issue dropped, and I moved on. Then last week, a committee chair I barely knew stopped me at the mailbox cluster. He leaned in and said quietly, "The file cabinet is missing a folder from the year of the incident." I asked which incident. He just looked at me and walked away. 2 days later, Martha showed up on my driveway with the clipboard and the screenshot demand. I told Martha I had proof. She said proof did not matter unless it was submitted the right way. I asked what the right way was. She said portal upload with a scanned copy and a notarized affidavit. I asked if that was in the rules. She said it was implied. I asked where. She said it was vendor coordinator discretion, and she was the vendor coordinator. That night I logged into the HOA portal and searched my account. The payment confirmation I uploaded in June was gone. No record, no receipt, no audit log entry. I checked my email archives and found the original upload confirmation from the portal with a timestamp. I screenshot the email, then checked the portal again. Still nothing. Someone had deleted it after receipt. I wrote down every word, because later I planned to read them back to her. I started a document with timestamps, names, and exact quotes. Martha had a megaphone she used at the mailbox cluster to announce rules, and she had been using it more often in the past month. Every time she showed up, she made a point of standing near my building and reading off violations for properties that did not match any real address. It felt like a warm-up. The next morning, I got an email from the management company. It said my account had multiple unresolved violations, and I needed to submit documentation by end of business or they would refer the matter to collections. The email listed 3 separate violations, 2 of which I had never heard of, and one that matched the June parking complaint. I replied with my proof and asked for clarification. The management company sent a second email an hour later with contradictory instructions. They said I needed to submit a new form that did not exist on the portal, and the deadline was now 24 hours earlier than the first email claimed. I called the management company. The rep who answered said she could not discuss individual accounts without written authorization from the board. I asked who on the board I needed to contact. She said the vendor coordinator. I asked if that was Martha. She said yes. I asked if there was anyone else. She said no. I hung up and called back. A different rep answered. I asked the same questions. This time the rep said the board president could authorize access. I asked for the board president's contact. The rep said they could not give that out without a records request. I submitted a records request that afternoon. The form asked for a specific description of the documents I wanted. I listed the meeting minutes from June 3 years ago, the violation notice template used that month, and any correspondence between the board and the management company about vendor authorization forms. I submitted the request through the portal. 2 days later, I got a reply that said the request was incomplete and I needed to resubmit with notarized signatures. I printed the original portal confirmation showing I had submitted it correctly. I took the printout to the management office. The lobby was small and fluorescent bright. A woman behind the counter looked up when I walked in. I handed her the printout and said I needed clarification on the records request. She scanned it and said the request had been denied because it was too broad. I pointed to the specific list of documents. She said it was still too broad. I asked what would make it narrow enough. She said I needed to specify exact dates and file names. I said I did not have file names because I was requesting files I did not have. She said that was a problem I needed to solve before resubmitting. I left the office and sat in my car. The tow yard closes at 6, and if they take my vehicle, I cannot recover it until tomorrow. I could not afford to lose a day of work. I checked the time. It was 4:30. I had an hour and a half to figure out what Martha was doing before the window closed. I drove to the mailbox cluster. A neighbor I recognized was checking his mail. I asked if he remembered the violation notices from 3 years ago. He nodded and said half the neighborhood got them. I asked if he paid the fine. He said yes, because it was easier than fighting. I asked if he ever got a refund. He said no. I asked if anyone else had asked questions. He said one guy did, but he moved out 6 months later. I asked the neighbor if he still had his notice. He said he might have it in a box somewhere. I gave him my number and asked him to text me a picture if he found it. He said he would try. I thanked him and walked back to my car. My phone buzzed. It was a text from the neighbor with a picture of a violation notice. The notice was identical to mine, down to the letterhead and the signature line. The date was different, but the wording was the same. I zoomed in on the signature. It was not signed. It was a scanned image of a signature, and the scan line was visible. I saved the image and checked the metadata. The creation date was 2 days after the notice date. Someone had backdated the template and printed a batch. I texted the neighbor and asked if he knew anyone else who still had their notice. He replied with 3 names. I sent a group text asking if anyone had kept their paperwork. 2 people replied within 10 minutes. Both sent pictures. Both notices had the same scanned signature and the same metadata mismatch. I had 3 pieces of evidence. I needed more. I called the county clerk and asked if HOA violation notices had to be filed anywhere. The clerk said no, but board resolutions and rule changes had to be recorded if they affected property rights. I asked how to search recorded resolutions. The clerk said I could come in and request a search by association name. I said I would be there in the morning. That evening, Martha showed up at my door. She was holding a clipboard and wearing the reflective safety vest. She said she was conducting a surprise inspection and needed to verify my vehicle registration. I asked if she had scheduled the inspection. She said inspections did not require scheduling. I asked if the board had authorized it. She said the vendor coordinator had standing authority. I asked to see the resolution. She said I could request it through the portal. I said I already had, and the request was denied. She said that was not her problem. She walked toward my parking space. I followed her. She took pictures of my car with her phone. I asked what she was documenting. She said potential violations. I asked what violations. She said non-compliance with vendor authorization procedures. I said I had not hired a vendor. She said parking enforcement contractors counted as vendors. I said I did not hire a towing company. She said the HOA did, and that made me responsible for compliance. I asked Martha if she had ever deleted portal uploads. She said no. I asked if the management company had ever deleted uploads. She said that was a technical question, and I should contact support. I asked if she had access to the portal backend. She said vendor coordinators had administrative access for compliance purposes. I asked if that included deletion rights. She said it included whatever was necessary to enforce the rules. I pulled out my phone and opened the recording app. I did not tell her I was recording. Colorado is a one-party consent state. I asked her again if she had deleted my June upload. She said she did not recall. I asked if she had access to the audit log. She said audit logs were internal documents. I asked if I could request them. She said no. I asked why. She said because they were internal. She stood up and walked back toward my door. She said I had until tomorrow at noon to submit a corrected vendor authorization form or the matter would proceed to a hearing. I asked what form. She said the form was available on the portal. I checked the portal on my phone. There was no form. I showed her the screen. She said it was under vendor compliance. I navigated to vendor compliance. The section was empty. She said I was looking in the wrong place. I asked where the right place was. She said that was my responsibility to figure out. She left. I saved the recording and texted my neighbor with the drone. His name was Eric, and he had helped me with a property line dispute the year before. I asked if he could get an overhead view of the mailbox cluster and the management office. He said he could fly tomorrow morning. I said that would work. The next morning I went to the county clerk. I requested a search for all recorded resolutions from the villas at Lakeview Property Owners Association. The clerk pulled up the database and printed a list. There were 4 resolutions on file. None of them mentioned vendor authorization forms. I asked if resolutions had to be recorded to be enforceable. The clerk said it depended on the governing documents, but anything affecting property rights or imposing fees generally had to be recorded. I asked for copies of the 4 resolutions. The clerk printed them and charged me $2. I read through the resolutions in my car. 2 were about landscaping assessments. 1 was about parking enforcement. The parking resolution authorized the board to contract with a towing company, but it did not mention authorization forms or vendor compliance procedures. The rule Martha kept quoting was never properly adopted, and the paperwork was blank where the compliance section should have been. I drove to the management office. The same woman was behind the counter. I handed her the resolutions and asked if the vendor authorization requirement had ever been formally adopted. She looked at the paperwork and said she could not comment on board decisions. I asked if she could confirm whether the rule was in the governing documents. She said I needed to request the documents through the portal. I said I had, and the request was denied. She said I needed to resubmit with more specificity. I asked to speak to a manager. She said the manager was not available. I asked when the manager would be available. She said she could not give out that information. I set my phone on the counter and opened the recording app. I said I was recording for my records and asked again if the vendor authorization rule was in the governing documents. She hesitated, then said she needed to check with her supervisor. She went into a back office. I waited. She came back 5 minutes later with a man in a polo shirt. He introduced himself as the property manager and asked what I needed. I repeated my question. He said the vendor authorization rule was part of the compliance manual, which was adopted by board resolution in 2019. I showed him the 4 resolutions. He scanned them and said the compliance manual was referenced in the parking resolution. I pointed to the blank section. He said the manual was a separate document. I asked for a copy. He said it was not publicly available. I asked why. He said it was an internal operational document. I asked if the board had ever voted to adopt the manual. He said yes. I asked for the meeting minutes. He said I needed to submit a records request. I said I had, and it was denied. He said he could not speak to why it was denied. I asked who could. He said the board. I asked how to contact the board. He said through the management company. I asked if he was the management company. He said yes. I asked if he could facilitate contact. He said he could pass along a message. I said I wanted to request the meeting minutes and the compliance manual. He said he would pass it along. I left the office and called Eric. He said he had the drone footage and would send it over. I asked what it showed. He said Martha had been at the mailbox cluster for 20 minutes that morning, and she had used the megaphone to announce a new parking enforcement sweep. He said at least 6 residents had stopped to listen, and 2 had argued with her. I asked if he caught the argument on video. He said yes. I asked him to send everything. If you are enjoying this story, hit the like button and subscribe for more wild HOA drama and neighborhood justice. The footage arrived an hour later. I watched Martha at the mailbox cluster, megaphone in hand, reading off a list of violations that did not match any actual properties. 2 residents confronted her. She told them the violations were based on contractor reports and they needed to submit authorization forms. 1 resident asked what forms. Martha said the forms were on the portal. The resident pulled out her phone and checked. She said there were no forms. Martha said that was a compliance issue and walked away. I now had the recording of Martha admitting she had deletion rights, the metadata from the backdated notices, the county resolutions showing the rule was never adopted, and the drone footage of Martha announcing enforcement of a rule that did not exist. I needed one more piece. I needed proof that Martha had been targeting me specifically, and I needed it on the record. I went back to the mailbox cluster that afternoon. Martha was there with the megaphone. I walked up and asked if she had a minute. She said no. I asked if she could clarify the vendor authorization rule. She said it was not her job to explain rules. I said the county clerk told me the rule was never recorded. She said the clerk was wrong. I said I had the resolutions. She said resolutions did not cover operational manuals. I asked if the manual had been voted on. She said yes. I asked for proof. She said I could request it through the portal. I asked if she remembered deleting my June upload. She said she did not delete anything. I said the portal audit log would show it. She said audit logs were confidential. I said I had a right to see my own account activity. She said I did not. I asked why. She said because the portal was HOA property and I was a resident, not an owner of the system. I said I was a homeowner and the HOA was a collective. She said that was not how it worked. I asked her directly if she had altered any violation notices. She said no. I asked if she had printed notices using a template with a scanned signature. She said all notices used approved templates. I asked if the templates were approved by the board. She said yes. I asked for the approval resolution. She said it was in the minutes. I asked which meeting. She said she did not have that information available. I asked how I could get it. She said records request. I said my request was denied. She said that was my problem. You think this is petty? I think this is my purpose, she said, and walked away. I stood there with my phone still recording. A neighbor approached and asked if I was okay. I said I was fine. She said Martha had been doing this to contractors for months. She said her HVAC guy refused to come back after Martha threatened to have him towed for parking in a guest spot. I asked if she had reported it. She said she tried, but the management company said it was a vendor compliance issue and she needed to talk to the vendor coordinator. I asked if anyone else had complained. She said at least 3 other residents had, but nothing changed. That night, I went through the portal one more time. I found a section I had not noticed before, buried under account settings. It was labeled Compliance History, and it had a list of uploads and deletions. My June upload was there, marked as deleted by administrator on June 10th at 11:47 p.m. The deletion was 3 days after I uploaded the file. I screenshot the log and saved it to 3 different places. I now had everything I needed. I called the management company and requested a board meeting to present evidence of procedural violations. The rep said board meetings required advance notice, and I needed to submit an agenda item request. I submitted the request through the portal. 2 hours later, I got a reply. The next meeting was in 3 weeks, and the agenda was full. I replied and said this was time sensitive. The rep said all matters were time sensitive and I needed to wait my turn. I did not have 3 weeks. The tow threat was still active, and Martha had made it clear she was not backing down. I needed to force the issue faster. I called the towing company directly. I asked if they had a contract with the HOA. The dispatcher said yes. I asked if they required written authorization before towing a vehicle. The dispatcher said yes, they needed a signed work order from the property manager or the board. I asked if they had ever received authorization from a vendor coordinator. The dispatcher paused and said vendor coordinator was not a recognized title in their contract. I asked what titles were recognized. The dispatcher said property manager, board president, and board secretary. I asked if the dispatcher could confirm whether any recent tow requests had come from someone using the title vendor coordinator. The dispatcher said they could not give out that information without a formal request. I asked how to make a formal request. The dispatcher said I needed to submit it in writing to the company office. I asked for the address. The dispatcher gave it to me. I thanked them and hung up. The towing company office was 20 minutes away. I drove there the next morning. The office was in a strip mall next to a tire shop. I walked in and asked to speak to someone about a contract verification. A woman behind the desk said the manager was out but would be back in an hour. I said I would wait. She offered me a chair. I sat down and opened my phone. I reviewed my evidence list. I had the portal audit log, the backdated notices, the county resolutions, the drone footage, the recording of Martha admitting deletion rights, and the towing contract language. I was close. The manager came back 50 minutes later. I explained the situation. I said I was a resident at the villas at Lakeview, and I believed someone was issuing tow authorizations without proper board approval. The manager asked if I had proof. I showed him the recording of Martha claiming vendor coordinator authority. He listened and said vendor coordinator was not in their contract. I asked if they had received any recent requests from Martha. He said he could not confirm that without a subpoena. I asked if he could confirm the contract language. He pulled up the file and showed me the authorization section. It listed property manager, board president, and board secretary. Vendor coordinator was not there. I asked if the company had ever towed a vehicle based on a request from someone not listed in the contract. The manager said no, they always verified authorization before dispatching. I asked if they had a record of who authorized recent tows at the property. He said yes, but he could not share it without resident consent or a legal request. I asked if I could request my own tow records. He said if I had been towed, yes. I said I had not been towed yet, but I had been threatened. He said threats were not in their system. I left the office and sat in my car. I had confirmed that Martha did not have authority to order tows, but I still needed to prove she had been trying. I called Eric and asked if he could fly the drone over the property entrance and the management office one more time. He said he could do it that afternoon. I asked him to focus on any interactions between Martha and contractors or tow trucks. He said he would. That afternoon, Eric sent me a new clip. It showed Martha standing in the parking lot talking to a tow truck driver. She was holding her clipboard and pointing at a car. The driver was shaking his head. Martha pulled out her phone and appeared to be showing him something. The driver looked at the phone, then walked back to his truck and drove away without towing anything. I texted Eric and asked if he had audio. He said no, the drone was too far away. I asked if he could get closer next time. He said he would try. I now had video of Martha attempting to order a tow without authorization. I needed to catch her doing it again, and I needed to get her on record admitting it. I decided to bait her. I parked in a guest spot the next morning, even though I had an assigned space. Guest spots required a placard, and I did not put one up. I waited. Martha showed up an hour later. She took pictures of my car and called someone. I watched from my window. She hung up and walked toward my building. I met her at the door. She said my car was in violation and would be towed within the hour. I said I had not received a notice. She said verbal notice was sufficient. I asked who authorized the tow. She said she did. I asked under what authority. She said vendor coordinator. I said vendor coordinator was not an authorized title in the towing contract. She said I was wrong. I said I had confirmed it with the towing company. She said they were mistaken. I pulled out my phone and called the towing company on speaker. The dispatcher answered. I said I was calling to confirm authorization for a tow at the villas at Lakeview. The dispatcher asked who was authorizing. I said the vendor coordinator. The dispatcher said vendor coordinator was not a recognized title. Martha grabbed for my phone. I stepped back. The dispatcher asked if there was a property manager or board officer available. I said no. The dispatcher said they could not proceed without proper authorization. Martha said the authorization was on file. The dispatcher said they had no such file. Martha ended the call. Martha said I was interfering with HOA business. I said I was protecting my property from an unauthorized tow. She said the tow was authorized by board resolution. I said I had reviewed all recorded resolutions and there was no authorization for vendor coordinators to order tows. She said the resolution was in the compliance manual. I said the compliance manual was never adopted. She said it was adopted in 2019. I said the parking resolution from 2019 had a blank compliance section. She said I was reading it wrong. I asked her to show me the resolution. She said she did not have it with her. I asked where it was. She said it was on file with the management company. I said I had requested it and been denied. She said that was because my request was incomplete. I said I had specified the exact document. She said I had not specified the file name. I said I did not have the file name because the document did not exist. She said it existed, and my failure to find it was not her problem. I asked her if she had ever deleted portal uploads. She said no. I pulled up the audit log screenshot on my phone and showed her the deletion entry. She looked at it and said the log was inaccurate. I said the log was generated by the portal. She said the portal had glitches. I asked if she was claiming the deletion never happened. She said she was claiming the deletion was justified if it did happen. I asked under what policy. She said compliance policy. I asked where the compliance policy was documented. She said in the manual. I said the manual was never adopted. She said it was, and this conversation was over. She walked away. I saved the recording and called the property manager. I said I needed an emergency meeting to present evidence of procedural violations and unauthorized enforcement actions. The manager said emergency meetings required board approval. I said the board was violating its own governing documents. The manager said that was a legal claim and I needed to consult an attorney. I said I had evidence. The manager said evidence needed to be submitted through proper channels. I said the proper channels were being blocked by the person committing the violations. The manager said he could not comment on personnel matters. I hung up and called an attorney. The consultation was free. I explained the situation. The attorney said I had a strong case for selective enforcement and procedural violations, but litigation would take months and cost thousands. I asked if there was a faster option. The attorney said I could file a complaint with the state regulatory board, but that would also take time. I asked if I could force a special meeting. The attorney said yes, if I could get 10% of the homeowners to sign a petition. I asked how many homeowners that was. The attorney said the association had about 200 units, so I needed 20 signatures. I spent the next 2 days collecting signatures. I went door to door with a one-page summary of the evidence and a petition requesting a special meeting to address procedural violations and unauthorized enforcement. Most people signed. A few said they did not want to get involved. One person said Martha had threatened to fine them if they supported any complaints against the board. I asked if they had proof. They said no, it was a verbal threat. I added their statement to my evidence file. I submitted the petition to the management company. The manager called me the next day and said a special meeting was scheduled for the following week. I asked if the board had been notified. He said yes. I asked if Martha would be there. He said all board members were required to attend. I asked if I could present evidence. He said I would have 10 minutes during the open forum. I said 10 minutes was not enough. He said that was the rule. I said I needed at least 20. He said he would ask the board. The board approved 15 minutes. I prepared a presentation. I printed copies of the audit log, the backdated notices, the county resolutions, the towing contract language, the drone footage stills, and the recording transcript. I organized everything into a binder with tabs. I practiced my delivery. I timed it. 14 minutes. The meeting was in the clubhouse. About 40 residents showed up. The board sat at a table in the front. Martha was there, wearing the red blazer and the reflective safety vest. She saw me, and her expression did not change. The board president opened the meeting and called for the open forum. I stood up and walked to the front. I introduced myself and said I was presenting evidence of procedural violations and unauthorized enforcement actions by the vendor coordinator. I started with the portal audit log. I showed the deletion entry and explained that my payment proof had been removed after submission. Martha interrupted and said the deletion was a technical error. I said the log showed it was an administrator action. She said administrators had to correct errors. I said the upload was not an error. She said it was incomplete. I showed the original upload confirmation. She said the confirmation did not prove the file was valid. I moved to the backdated notices. I showed the metadata and the scanned signature line. Martha said all notices used templates. I said the templates had been backdated. She said the dates were accurate. I showed the creation timestamps. She said timestamps could be wrong. I said 3 separate notices had the same mismatch. She said that proved nothing. I moved to the county resolutions. I showed the blank compliance section. Martha said the compliance manual was a separate document. I asked where the manual was. She said it was on file. I asked to see it. She said it was not available at the meeting. I asked when it would be available. She said I could request it through the portal. I said I had requested it and been denied. She said I needed to resubmit. I moved to the towing contract. I showed the authorization language. I played the recording of the dispatcher saying vendor coordinator was not a recognized title. Martha said the contract was outdated. I said the contract was dated 6 months ago. She said the board had verbal agreements. I asked for proof. She said verbal agreements were not documented. I asked how residents were supposed to know about them. She said residents were expected to comply with board decisions. I moved to the drone footage. I played the clip of Martha talking to the tow driver. Martha said she was asking a question, not ordering a tow. I said the driver left without towing because she did not have authorization. She said the driver left because the car was moved. I said the car was not moved, I had timestamp photos. She said I was lying. I moved to the final piece. I played the recording of Martha admitting she had deletion rights and claiming the audit log was inaccurate. The room went silent. Martha said the recording was taken out of context. I said the context was clear. She said I had edited it. I said I had the full unedited file. She said I was harassing her. The board president asked if I had more evidence. I said yes. I pulled out a printed packet. It was a portal audit log showing my uploads were deleted after receipt, not just the June file but 3 others over the past year. I had requested the full log from the management company that morning, and they had sent it without realizing what it contained. I handed copies to the board and the audience. Martha stood up. She said the log was confidential and I had no right to share it. I said it was my account activity and I had every right. She said I was violating privacy rules. I said there were no privacy rules in the governing documents. She said the compliance manual covered it. I said the compliance manual was never adopted. She said it was adopted in 2019. I held up the resolution with the blank compliance section and said this is what you keep quoting, and it is blank. The board president asked the property manager to confirm whether the compliance manual had been formally adopted. The manager said he would need to check the records. Martha said the records were clear. The manager said he would check and report back. Martha said there was nothing to check. The manager pulled out his laptop and opened a file. He scanned it and said the meeting minutes from 2019 did not show a vote on the compliance manual. Martha said the vote was implied. The manager said votes had to be explicit. Martha said he was wrong. The board president asked Martha if she had any proof the manual was adopted. Martha said the proof was in the file cabinet. The president asked which file cabinet. Martha said the one in the management office. The president asked the manager to retrieve the file. The manager said he would check after the meeting. Martha said the file was there. The president said if the file was there, it would be presented at the next meeting. Martha said this was a waste of time. A resident in the back raised her hand and said Martha had threatened to fine her for supporting my complaint. The president asked if the resident had proof. The resident said it was a verbal threat. The president said verbal threats could not be verified. I said I had 3 other residents with similar complaints. The president said they could submit statements in writing. I said they were afraid of retaliation. The president said the board could not act on unverified claims. Another resident stood up and said Martha had been harassing contractors for months. He said his plumber refused to come back after Martha threatened to have him towed. The president asked if the resident had documentation. The resident said he had a text from the plumber. The president said texts were not official evidence. I said the pattern was clear. The president said patterns were not proof. Eric stood up and said he had additional drone footage showing Martha using the megaphone to announce rules that were not in the governing documents. He said he could provide the full file. The president said the board would review it. Martha said drones were prohibited. Eric said they were not. Martha said they violated privacy. Eric said he was flying over common areas. Martha said common areas were HOA property. Eric said HOA property was collectively owned by residents. Martha said that was not how it worked. The president called for a 5-minute recess. The board huddled at the front table. Martha was talking fast and pointing at the binder. The property manager was shaking his head. The board secretary was taking notes. The recess stretched to 10 minutes. The president finally called the meeting back to order. The president said the board would launch an internal review of the vendor coordinator role and the compliance procedures. Martha said there was nothing to review. The president said the review was necessary. Martha said it was a witch hunt. The president said the board had a fiduciary duty to investigate procedural concerns. Martha said the concerns were baseless. The president said the evidence suggested otherwise. The president said the board would suspend all pending violations and tow authorizations until the review was complete. Martha said the board did not have authority to suspend her actions. The president said the board had authority over all enforcement actions. Martha said vendor coordinators had independent discretion. The president said there was no such provision in the governing documents. Martha said it was in the compliance manual. The president said the compliance manual had not been adopted. Martha stood up and said she was resigning from the vendor coordinator role effective immediately. The president said the resignation was accepted. Martha said she was also filing a complaint against me for harassment. The president said residents had a right to challenge board actions. Martha said I had exceeded that right. The president said the board would determine that. Martha walked out. The room erupted. Half the residents were clapping. The other half were talking over each other. The president banged the gavel and called for order. He said the meeting would continue. I asked if I could submit my evidence to the record. The president said yes. I handed the binder to the secretary. The president said the board would meet in executive session to discuss next steps. I asked if the session would be open to residents. The president said executive sessions were closed by statute. I asked when the board would report findings. The president said within 30 days. I left the meeting and walked to my car. My phone buzzed. It was a text from Eric. He said Martha had just driven past the clubhouse at high speed and nearly hit a speed bump. I replied and said she was probably heading to the management office to grab the file cabinet. Eric said he would fly the drone over there in the morning. I said that would be perfect. The next morning, Eric sent me a message. He said the management office was locked and the file cabinet was gone. I called the property manager. He said he did not know anything about a missing file cabinet. I asked when he last saw it. He said he could not recall. I asked if anyone had access to the office overnight. He said only staff and board members had keys. I asked if Martha had a key. He said vendor coordinators had temporary access for inspections. I asked if temporary meant overnight. He said it depended on the situation. I drove to the management office. The door was locked. I looked through the window. The office looked normal except for an empty space where a file cabinet used to be. I took a picture. I called the board president and left a message. I said the file cabinet Martha mentioned was missing, and I had reason to believe it contained evidence relevant to the review. The president called me back an hour later. He said the board was aware and had asked the property manager to investigate. I said the manager claimed he did not know anything. The president said the board would follow up. 2 days later, the property manager called me. He said the file cabinet had been located in a storage unit rented by the previous property manager. He said the board was reviewing the contents. I asked if I could see the files. He said no, they were confidential board records. I asked if the compliance manual was in the files. He said he could not confirm. I asked when the board would report findings. He said the 30-day timeline was still in effect. 3 weeks later, the board held another meeting. The president announced that the internal review had found multiple procedural irregularities. He said the vendor coordinator role had been operating without formal authorization, and several enforcement actions had been taken without proper board approval. He said the board was adopting a board resolution that suspends towing until authorization rules are fixed. He said the compliance manual referenced in the 2019 parking resolution had never been formally adopted, and all enforcement actions based on the manual were void. The president said the board was also adopting new procedures requiring all enforcement actions to be approved by the board or the property manager in writing. He said the board had reviewed the portal audit log and confirmed that multiple resident uploads had been deleted without cause. He said the board was issuing refunds to affected residents and implementing new audit controls. He said the board was referring the matter to an attorney for a legal opinion on potential liability. The president said the board had voted to restructure the vendor coordinator role, and Martha was told to step down and she cannot spin it. He said a new coordinator would be appointed with clearly defined responsibilities and oversight. He said the board had also voted to engage in mediation, and the HOA agrees to mediation with a neutral third party to address resident concerns about selective enforcement and transparency. The president said the board had identified several archived complaints from 3 years ago that matched the current evidence. He said the complaints had been dismissed at the time based on representations that the compliance manual was in effect, but those representations were false. He said the board was reopening those cases and issuing refunds. He said the doorbell video from one of the archived cases had been reviewed, and it showed Martha delivering a violation notice and claiming she had never been to the property. Karen claims she never came by and the doorbell video plays, the president said, and that level of dishonesty is unacceptable. The room was silent. The president asked if there were any questions. I raised my hand and asked if the board would be taking action against Martha. The president said the board was consulting with an attorney about potential options, including removal from the board. I asked if criminal charges were being considered. The president said the board was not aware of any criminal conduct at this time, but if evidence emerged, it would be referred to authorities. A resident asked if the board would be compensating residents for time and expense related to fighting bogus violations. The president said the board was reviewing that question and would announce a decision within 60 days. Another resident asked if the board would be replacing the property manager. The president said the property manager had cooperated with the review, and the board had no plans to terminate the contract. The meeting adjourned. I walked to my car. My phone buzzed. It was a text from Eric. He said congratulations. I replied and said it was not over yet, but it was a start. He said the drone footage was still available if I needed it for anything. I said I would keep that in mind. The refund check arrived 2 weeks later. It covered the bogus fines from June and the 2 other deleted uploads. The check also included interest and an apology letter from the board. The letter said the board regretted the procedural failures and was committed to ensuring they did not happen again. The letter was signed by the board president, not Martha. I deposited the check and updated my evidence file. I kept everything organized in case the attorney needed it later. I also kept recording every interaction with the HOA just in case. The new vendor coordinator reached out a week later and introduced herself. She said she was reviewing all open cases and wanted to confirm that my account was clear. I said it was. She said if I had any concerns in the future, I could contact her directly. I said I appreciated that. Martha did not show up at the next board meeting. The president announced that she had resigned from the board entirely. He said the board had accepted the resignation and thanked her for her service. A few residents clapped, but most stayed quiet. I did not clap. I just watched the board vote on the new enforcement procedures and the mediation agreement. The mediation session happened a month later. It was held at a neutral office with a retired judge as the mediator. The board sent 3 representatives, including the president and the new property manager. I brought Eric and 2 other residents who had been affected by the bogus violations. The mediator asked each side to present their concerns. I walked through the evidence again. The board representatives acknowledged the failures and proposed a settlement. The settlement included additional refunds, a formal apology, and a commitment to transparency reforms. I accepted. The case was closed 3 months after I reopened it. The cold case that had been buried for 3 years was finally resolved. The file cabinet that had been missing turned out to contain copies of complaints from a dozen residents, all dismissed without investigation. The board issued a public statement acknowledging the failures and promising reforms. Martha was gone, and the new procedures were in place. I still live at the villas at Lakeview. The neighborhood is quieter now. The megaphone is gone. The surprise inspection stopped. The portal works. The enforcement actions are transparent. The towing company checks authorization before dispatching. The board meetings are recorded and posted online. The compliance manual was formally adopted after a proper vote, and it is available to all residents. Eric still flies his drone. He sends me clips of the neighborhood when something interesting happens. The new vendor coordinator waves when she sees me. The management company returns my calls. The board president nods when we pass in the parking lot. It is not perfect, but it is better. I kept the binder. I kept the recordings. I kept the drone footage. I kept the audit log. I kept everything. Because in an HOA, you never know when you will need proof, and you never know when a cold case will come back to life. I appreciate you supporting the channel.